Hello, my name is Hannah Sullivan, and for my final presentation, I choose the FERPA as my legal act that I wanted to, or my legal issue that I wanted to explain for my final project. The class is EDUC 20 or 7040, and the title of the class is The Teacher in the Law, and I did my presentation on June 27th, 2022. So the definition of FERPA is that it is the Family and Education Rights and Privacy Act. It's a federal law. It protects the privacy of student education records. It applies to all schools that receive funds under an applicable program of the U.S. Department of Education, and the rights to the records are held by the parent or guardian of the student until the student becomes eligible, which means the student turns 18, or if they go to a higher education program such as college before they turn 18, then they would be considered eligible as well. So, what FERPA states is that eligible students or parents may review educational records at the school, but that the school is not required to provide copies. So that means if copies are requested for reasons such as the parents live too far away or they're just not able to come to the school for any reason, then the school is allowed to charge a fee for the copies. Parents or eligible students can request that records be corrected if they believe them to be incorrect. If the school refuses to correct them, the parent or eligible student are entitled to a formal hearing. After this formal hearing, if the school still does not correct the record, but the parent or eligible student still believes it to be incorrect, then a note about the speculated misinformation can be left within the record. Schools must have a written consent from either of the two eligible parties unless it or if it is to be disclosed to any party or for any reason in the attached link. And I'm going to just pull this up if it will let me to see just a brief overview of the parties that are not allowed or that we can get this information to without written consent. There are 9 reasons that this information can be disclosed without the consent of the eligible party, which would be the eligible student or their parent. And if we go down here, we can look at a brief overview of them. These reasons are right here. So we can go back and review these at any time. Now, concerns for the teacher. Why does FERPA concern teachers? Teachers are constantly corresponding and collaborating with others in order to provide the best resources and academic support for their students, and almost always have the student's best interest in mind. Now, I say almost always because as teachers, and sometimes we have a tendency to gossip about things that are going on in our daily lives, and it is important to understand that students' records and other student educational information are never anything that we can discuss with other teachers and other adults for any reason other than if they fall under these 9 qualifications that are over here. Now, if it's just my friend that teaches 3rd grade and I teach 4th grade and I want to talk about a student that they had the year prior that I have this year, that is never something that is okay under FERPA laws. So that's something that's important to keep in mind. Another concern is that all teachers should be aware of who is legally allowed to have access to the records before they begin discussing the student for any reason. So if one of my students' aunts or uncles calls me and asks for their average in my class, I am never allowed to disclose that information unless I have the written consent of the parent, or if my student is over 18 years old, I can have the written consent of the student himself. But as an elementary teacher, I can only have the written consent of that parent or guardian of my student. Um, it's also important for teachers to be aware of what is considered student record and what information is not considered student record. Therefore, what is considered to be okay to share with the public. So, if I'm just talking about my class in general on Facebook being the best at field day, that would not be considered educational record. So, therefore, it would be okay to share. But if I want to brag on one of the students that I am just so proud of and say that they have met their goal as an average of a 100 in my class for the year, that would be considered educational record if I share that student's name and their average. So therefore, that would not be okay to share with the public. One case that displays FERPA law in action is the Owasso School versus Falvo, and the decision was decided in 2002. To start, it was brought to the Supreme Court by Mrs. Falvo, who was a teacher in the Owasso School District, and it was brought over the issue of peer grading. Her children were in the school district, and they were embarrassed whenever other students graded their papers, because if they made a bad grade, of course, the other students would know what they made on that particular assignment, and they did not feel like that was fair. So Mrs. Falvo took that to court under the provisions that it was a violation of FERPA. Originally, the ruling was overturned by the 10th Circuit, and it went to the Supreme Court in 2001 because Mrs. Falvo was still not satisfied with the result. Eventually, in 2002, a decision was unanimously reached that stated no, the practice was not in violation of FERPA, since the grades had not yet been put into the teacher's file of grade, and it was not yet considered an educational record. So this means that because the students were just grading the papers on their own, maybe they had made a mistake, or for whatever reason, that grade would not be made official until the teacher looked back over the papers and then entered those grades into her gradebook. And if you would like this video right here, I'm going to highlight it. This is a YouTube video that gives another brief summary of the case, just in different wording, if you would like to read along with that. Another case that highlights the issues of FERPA is Bates College versus Congregation of Beth Abraham. This case was held in the Maine Supreme Court in 2001 on the issue of the student information being disclosed in email correspondence. Now, this case is important because it's one of the only cases where email is considered and mentioned during a Supreme Court case involving FERPA. For this case in particular, the plaintiff argued that student correspondence via email should not be disclosed to non-authorized parties on the grounds that it violated FERPA. In this case, the records specifically discussed could not be protected under FERPA because Bates College was a private institute. And under the provisions of FERPA, only institutions who are funded by federal funding are protected under FERPA, and because this was a public college, it did not fall under those categories. However, in the decision, it did include that if this was a public institution, that yes, the email correspondence of student record would be protected under the provisions of FERPA. So that means if I wanted to email to another teacher or email to another adult or ask questions, or maybe my students were emailing me about their records, those would be protected under FERPA. I would not be allowed to share them as a teacher with anyone who did not fall under, again, these 9 provisions that is written into the law. Now, how does this make sense for me as a teacher? The implications that it has for teachers are that teachers cannot share student information and student records to unauthorized parties, only to the eligible student or their guardian without written consent. As law is written, there are only certain circumstances that allow for these records to be shared without written consent, which can be reviewed in the following link. And this link right here is the same one that I have included previously that will take you to these following reasons about why they can be shared without consent to the following parties. If the teacher is unsure of something is considered protected under student records, or if the party requesting records needs permission to view, it is best for the teacher to keep information confidential prior to reviewing FERPA stipulations, and that is because if the information is found to be shared in violation of FERPA, then the teacher could be in jeopardy of losing their license, losing their career, and it's just better for the parties all around to be protected, and we don't want to share information if it makes anyone uncomfortable in the first place. So if we're unsure if this information should be shared or not. We should just keep it to ourselves until we review the law. And my references down here are as follows.